This talk is about the implications of the Tornado Cash prosecutions that we're seeing in the Netherlands and in the Southern District of New York in the United States. I want to start with my background and a disclaimer. I am an attorney at Coin Center. Coin Center is not a law firm, it's a civil liberties advocacy organization. We're based in Washington, D.C., and we have been operating since 2014 to try and educate people in government, especially the US government, about these technologies so that they can make good policies out of a position of knowledge rather than bad choices out of a position of ignorance, and ultimately to defend people's digital civil liberties. I am a lawyer, but I'm not your lawyer, so if you're watching this talk and you think you're taking some useful legal advice from me, you're not. If you're building in this space, as you'll see in this talk, you are potentially facing very real risks and very specific risks based on what you are actually doing, the specifics of what you're doing. And so whether you like it or not, it's wise to actually talk with a lawyer who you hire who represents your interests, and you can figure out your own risk appetite. Coin Center is here to advocate, especially in the legislature and in the courts, to the extent we do bring lawsuits, for broad crypto-friendly interpretations of underlying constitutional law. So a broad interpretation of the First Amendment that would protect more activities under the heading of free speech expressive activities, though those interpretations may not always win in court. We're also here to advocate for reasonable and narrow interpretations of criminal laws, of regulatory policies, things like what we will discuss with respect to liability for money laundering or liability for unlicensed money transmission in this talk. We make the strongest case for these interpretations in order to move the Overton window to get good policy that protects innovators and to make sure that people who are just trying to build important tools for human flourishing don't end up on the wrong side of a prosecution, and certainly don't end up in jail if they do get prosecuted. But you should not rely on these interpretations. You should talk to a lawyer. And if after talking to a lawyer, or maybe even just after listening to this talk, you are building privacy tools and you think, well, I don't know if I want to build privacy tools anymore because of the legal risks, I totally get you. The space has gotten a lot more frightening just over the last 2 years, and the risks are very real. And that, unfortunately, is exactly why this fight right now is very important. Because people are no longer, some people are, for very reasonable justifications, not building these tools or not publicly building these tools because they're afraid of prosecution. And if there's anything that the American First Amendment is intended to protect, it's the marketplace for ideas. And these overzealous prosecutions, I would argue, are effectively chilling this market for ideas, saying, you know what, maybe we don't need more ideas and innovations about personal financial privacy. Just don't come up with those ideas. And if you do come up with those ideas, maybe you'll go to jail. That's not an open society. That's not a liberal democracy. That's a form of totalitarianism. So, with that, table setting. This is one of 2 talks I'm giving on this visit to Berlin. Both talks deal with the implications of the recent Tornado Cash prosecution. This one's focused on the money laundering charges and the unlicensed money transmission charges and the nature of conspiracy, criminal conspiracy charges generally. And I'm also going to cover the samurai indictment a little bit. The other talk will focus on US sanctions laws, which in some ways triggered this whole situation when OFAC sanctioned the Tornado Cash tool in August of 2022. That sanctions law talk will be at ETH Berlin tomorrow at 17:30. So I just want to throw the timeline up here so that for people who are just looking for basic news about where we are in these prosecutions. It all started in August 2022 with the sanctions being announced and Alexei being arrested in the Netherlands. Some months later, Alexei was charged after being held without charges in jail and no bail. He was charged with money laundering. In August of 2023, Roman Storm was arrested, and Storm and Semenov, other co-developers of the Tornado Cash protocol, were indicted in the Southern District of New York. And they were charged with conspiracy to launder money, to do unlicensed money transmission, and to violate sanctions. In March of 2024, Roman Storm filed a motion to dismiss the charges against him, arguing that the DOJ had insufficiently pleaded any criminal behavior for which he could be held culpable. And the government filed a reply brief this past April arguing that they do think they sufficiently alleged money laundering, unlicensed money transmission, and violations of sanctions. I bring this up because this is the most recent big, comprehensive statement of how the government sees the laws applying in this space in the US, and it is extremely broad. Now, a prosecutor has to make the strongest arguments they can legally in the hopes of winning a case. That's their job. But I would say a prosecutor should not be making arguments that clearly go against or contradict existing law and precedent. And this brief comes really close, quite frankly. And so if you want to see the absolute broadest interpretation of where you could be liable for developing privacy tools, this is a good place to start looking. It's the broadest theory of unlicensed money transmission and money laundering culpability that you'll find, at least in the US system. In April, developers of the Samurai wallet, which was a Bitcoin wallet that did confidential transactions as a way to improve privacy, the developers were indicted in the Southern District of New York as well. They were charged with conspiracy to launder money and unlicensed money transmission, two of the same charges as in the Tornado Cash case. And in May of 2024, a verdict was announced in the Dutch case for Alexei, and he was sentenced to 64 months of jail. These three things are what the remainder of this talk's going to focus on, because I think there's a lot to be gleaned from what's happened most recently in these three indictments and the verdict. So I want to start with some key background concepts and distinctions that people in this space who are building privacy tools should be aware of. I think if you're not a lawyer and you just read the news, it just looks like prosecution, and you may not be, aware of the important distinctions in the way these prosecutions are being pursued, both in the SDNY and in the Netherlands. So the first thing to look at is what exactly is being charged, because the prosecution has to prove a different set of facts to prove a different crime. So money laundering, unlicensed money transmission, and sanctions evasion are the three things that are at stake in the SDNY. And in the SDNY, it's conspiracy to do these things. And this is important to note because this changes, again, the facts that the government has to present. If you actually launder money for someone, they have to prove your intent, that you knew that you were concealing the proceeds of some specific crime and actually did conceal them. If you want to prove conspiracy, you merely have to prove, if you're the government, that somebody agreed with a bunch of other people to knowingly conceal the proceeds of crime. And the question of when do you see agreement and how broad can the conspiracy be is highly relevant in this space. I think for obvious reasons, because a lot of these tools are either genuinely or sometimes ingenuinely, but quite often genuinely decentralized. And if you can make an argument that the conspiracy is everyone on the Ethereum blockchain that's mining, writing software, validating transactions, et cetera, then maybe it's going to be easier for the government to prove culpability for the development of a privacy tool. But at some point, this becomes absurd, because are we really all in agreement on the Ethereum blockchain that it should be used for illicit purposes? Are we all working together to help North Korea? That's ridiculous. What is the background law is another thing to keep in mind. So I'll go into it a little bit, but the Netherlands, for example, has a different standard of criminal intent for money laundering than the US. It has a very broad standard which could catch a lot of people as culpable, effectively, if it's interpreted the way it has been in the Pertsev verdict. It's basically a negligence standard. There's also other relevant law. There's underlying regulatory definitions in law. For example, if you're being charged with unlicensed money transmission in the US, the government is saying, you were doing money transmission, And we have laws on the books that say that those who are doing money transmission need to register with a particular regulator. In the case of money transmission, FinCEN, which is a division of Treasury. FinCEN has, through guidance and rulemakings, further clarified and defined what money transmission is. And we'll get into that a little bit. The problem is the DOJ doesn't necessarily need to give FinCEN's guidance weight and can say, well, even though you read the guidance as saying you weren't doing money transmission, we interpret the underlying authority in the statute as you doing money transmission for which you didn't have a license, even though the person you were supposed to get a license from said you didn't need a license. Finally, there's constitutional law defenses that vary based on jurisdiction. So in the United States, we have a fairly rich and robust tradition of protecting expressive conduct as speech, which means the government has to meet a very high burden of proof to justify regulations or criminal enforcements that chill or otherwise ban or limit speech activities. And so this could be a defense to overzealous prosecution in the United States. In the European tradition, there is less robust reasoning about what is speech and where the limits of the criminal law lie with regard to speech. And finally, there are distinctions to be drawn about what facts are alleged in any particular circumstance. If we're talking about just being liable for publishing and distributing privacy tool software, that's one thing. What about other things? What about maintaining a website that has a front end? What about broadcasting transaction messages, signed transaction messages, even if you have no control over the underlying funds? What about the use of relayers within a scheme, like in Tornado Cash? What about mining, validating, running coordination servers in the case of confidential transactions and the Samurai wallet indictment? And do you take fees? These all can potentially influence how likely it is that your activities will be either protected by the First Amendment or unprotected, how likely you will fit the factual patterns required to prove things like money laundering. I'm not going to go through this slide. You can take a picture of it. This is a rough breakdown of some of the distinctions. So for example, Alexei is being charged in the Netherlands for money laundering. The two Romans are being charged in the United States for all three of those offenses. Alexei is facing money laundering charges where the government only has to prove a Dutch intent standard, which is basically a negligence standard. In the US, the standard of intent, whether you knowingly and, if you will, willfully were facilitating money laundering, which is in many ways a stricter standard, though could be flexible even in this case. So with the remainder of my time, I want to get into some more specific areas and zoom in because there's a lot here. So as I said, the unlicensed money transmitting charges are particularly worrying because the DOJ appears to be taking this theory of what is money transmission for which you needed a license and building it out of whole cloth and ignoring the established guidance from the relevant licensing regulator, registering regulator, FinCEN, for the last 10 years, for longer than 10 years, actually. So this quote here from the motion in response to Roman's motion to dismiss from the DOJ says, Section 1960, this is the unlicensed money transmission statute in the United States, so this is how you criminalize unlicensed money transmission. Section 1960 does not require the business to have control of the funds. They argue that the definition is broader than the actual definition in the Bank Secrecy Act, which is the regulatory statute, and far broader than the narrow guidance that's been offered by FinCEN to date as to who is doing money transmission and needs to regulate, or needs to register with the regulator. This is the 2013 administrative ruling from FinCEN, where they clearly say that the production and distribution of software is not in itself money transmission, even if the purpose of that software is to facilitate transactions in virtual currency. Below it is the FinCEN 2019 guidance, where they said quite clearly that in the context of multi-sig wallets, as an example, even partial control over the user's funds is insufficient to classify the wallet developer as money transmitters, because, quote, the person participating in the transaction to provide additional validation at the request of the owner, the user of the wallet, and the owner of the funds in the wallet, does not have total independent control over the value. So obviously you can see a very big discrepancy between what the regulator has been saying is conduct that requires a license and what DOJ is charging the Romans for as far as conduct, saying they did things and they needed a license to do those things. Next, the DOJ says, okay, sure, FinCEN said that about wallet providers. They're addressing the motion to dismiss where that argument was raised by the Romans Defense Counsel. And they say, well, the Tornado Cash service is not a wallet provider. And there's a separate section of the 2019 FinCEN guidance that refers to cryptocurrency mixing services. I have a lot of problems with this argument. A, you can totally think of Tornado Cash as a wallet. What was Tornado Cash for? You put your money into the pool contract. You are the only person on earth that can take money out of the pool contract. It's very similar to how a metaphorical wallet or a real wallet works. You put your money in your wallet, it's in your pocket, you're the one that takes money out of the wallet. Setting that aside, though, it's true, you could also think of Tornado Cash as something like a mixer or a privacy tool. The problem is that FinCEN actually did talk about privacy tools in their 2019 guidance, and they said that an anonymizing service provider, this is their language, who is accepting value from a customer and transmitting it to the same or another transmitting the same or another type of value to the recipient is a money transmitter. Again, accepting and transmitting, which means in the interim, you have control over the funds. And FinCEN went further and said, an anonymizing software provider is not a money transmitter, and they are in fact exempt from a licensing requirement. So the DOJ makes a point. Tornado Cash isn't traditionally thought of as a wallet, so maybe FinCEN's wallet guidance is inappropriate. But nonetheless, FinCEN had guidance on exactly what Tornado Cash arguably was, which is an anonymizing software provider, and they said that's not money transmission. This is a very nuanced legal argument. I'm going to skip by this in my slides. Finally, this one bothers me a lot too. Consider the example of a business that accepts parcels of cash from criminals and moves the money by courier to locations overseas. The archetypal Section 1960 violation. The funny thing about this is, well, two things. A courier that has a locked box of cash has far more control over that transaction than any of the developers in the Tornado Cash protocol, or even a large interpretation of who is part of the conspiracy, if there is a conspiracy to do money transmission in Tornado Cash. So the metaphor is not even appropriate. But even if the metaphor that the DOJ is using was appropriate, armored car services that move funds from one location to another, where the same person is owed the funds, are exempt from licensing as money transmitters under FinCEN's own guidance. So even a metaphorical version of Tornado Cash that's like locked parcels being moved from one place to another on the blockchain for the owner of the funds, which is a pretty good metaphor for what Tornado Cash is doing, is exempt under FinCEN's regulatory guidance. The DOJ doesn't seem to care. They seem to just want to prosecute, and ignore the fact that the regulator on point has actually said the exact opposite of what they're saying about the law for 10 years. Briefly, the Samurai Wallet indictment. I want to say two things about this. One, you may have seen some reported facts about the Samurai devs. There is allegedly a tweet where one of the devs said, "We welcome all our new Russian oligarch users." Don't do that. This is not legal advice that you can rely on from me, but don't do that. A lot of this, as I said, has to do with intent standards. Was your intent to create privacy-protecting tools for the general good, which I think is the intent of most developers out there? Or was your intent actually to further money laundering? It's going to be very bad in court to try and say you didn't want to promote money laundering if you were encouraging sanctioned persons to use your tools. That aside, Samurai Wallet was still non-custodial. So the unlicensed money transmission charge, rather than the money laundering charge, is really hard for me to find a way to justify. It doesn't make sense. Yes, they ran a coordination server, at least that's the allegation, and I think that is how the Samurai Wallet worked, though I don't have personal knowledge of that. But even a coordination server for Bitcoin confidential transactions doesn't have independent control over the Bitcoins being moved through that wallet. Finally, the Pertsev verdict. The one thing I want to point out about the Pertsev verdict, and then I want to skip to questions so we have time to answer some questions, is that this standard is extremely broad for who's criminally culpable for money laundering. It's effectively a negligence standard. And this prosecution, unlike the Southern District of New York prosecution, didn't even focus heavily on the existence of trusted or semi-trusted relayers who were taking a fee. It focused pretty much exclusively in the verdict, in the actual reasoning for why they're culpable, on merely Alexei's failure to design software that had backdoors in it. It's a negligence standard. It says, well, sure, you didn't overtly promote or induce people to launder money using your tool, but you could have built your tool in a way that gave law enforcement a way to stop it or block people, and you didn't. And that's an incredibly broad standard that could trigger all kinds of criminal liability. And really, it's inappropriate for criminal liability to be this blunt object that states use to tell software developers the right and wrong ways to build innovative new tools. At least, that's my opinion. I'm going to skip through the rest of this so we can get to questions. Questions?
Thank you, Peter. We have some time for questions, so please raise your hands if you have any questions. Yes.
Yeah, I think those developments are all, not so great, I would say. Are there currently positive developments you see
So things that are making me more optimistic, probably the best thing to happen in the last week or so is that Senator Lummis and Senator Wyden, which I know this is Berlin and I'm going to bring up American politics, but a Democrat and a Republican, so it's not, it's not partisan, wrote a letter to the Attorney General and said, what is this unlicensed money transmission interpretation? You seem to be arguing something directly opposite to what the regulator FinCEN has been saying for the last 10 years, and you're scaring the crap out of people who are building innovative things. And this is a positive development. It's not going to carry weight in the Southern District of New York, but I think if the AG agreed, he could back down. I don't know if he will. He could order the DOJ to cool it. It has persuasive power also with the judge that people relied on this guidance for 10 years. At the very least, the Romans shouldn't be held criminally culpable because they relied in good faith on the statement of the regulator. And maybe at the best, the DOJ's legal reasoning here is just bogus. It's just wrong, which is what I think. So that's encouraging. I'm going to say this, and I don't know if this will get back to Ron Wyden, the senator, one of the two senators, but every time Ron Wyden gets excited about something in the crypto space, I feel a little bit more optimistic because he was a real hero in the early days of the internet in advocating within the Senate and the House before that for good policies that would allow devs to build a free and open internet. And so he's not always right there with the crypto stuff, and I kind of get that because some of the crypto stuff is kind of ugly, but he was right there for this, and this is what matters.
The Dutch case against Alexei Patsev, I know you're a lawyer, but not our lawyer, and also not a European lawyer.
Yeah.
But can you compare the Dutch laws here with other jurisdictions around the world? I mean, it seems to me that this is an incredibly wide, and I mean, if the standard is negligence, then it's really easy to kind of do this by mistake without intent and without knowing that you're doing it, right?
Negligence, yeah.
Exactly. So can you compare this to other laws around the world? I mean, this is Europe, so yeah.
So the one standard I can compare it to is the American standard, because that's where I have expertise. So the Dutch standard is, at least as explained in the verdict, and again, I'm not a Dutch lawyer, but I can read a translation, disclaimer, is acting with knowledge that there is a significant chance that you will facilitate the concealment of criminal proceeds, right? Or by your actions, criminal proceeds will be concealed. And so knowledge of a significant chance, it's incredibly broad standard. I mean, if I built almost any tool in the world, there's a significant chance that a criminal would pick it up and find a way to do bad things with it, right? So I just shouldn't build tools, is effectively what a negligence standard creates from a public policy perspective. In the United States, money laundering is a specific intent crime. It's not just a negligence crime, it's a tighter standard. And specifically, conspiracy to launder money, which is what the Romans are charged with, you have to prove that there was an agreement with a specific intent to further the object of the agreement. Now, I think there was definitely agreement amongst the Romans and others to build good tools for privacy. But did they have a specific agreement to facilitate money laundering? I think that's nonsense. And further, in the actual money laundering intent requirements, you find that there needs to be specific intent to conceal specific proceeds of crime. So it's very important to note that the Tornado Cash Protocol was made, the salient parts of the Tornado Cash Protocol were made immutable before all of the alleged criminal usage in the DOJ indictment. So it's not even as though the most relevant parts of the protocol were built with full knowledge that North Korea is about to use it. That's impossible. They can't predict the future. And so I think it's going to be harder for the prosecution to meet their burden in that intent standard, because it's not a backward-looking standard that says, oh, well, you could have done X, Y, and Z, and then the criminals wouldn't have had the benefit of your technology. It's a standard that says, no, you have to have had some specific intent to further the illegal act.
Thank you so much, Peter. That was brilliant.
Thank you.